Don't blink, otherwise you just might miss it. A precisely targeted effort to frustrate, if not destroy, the open system segment of the U.S. vaping industry. Earlier this year, the Consumer Product Safety Commission, which is the federal regulator responsible for enforcing the Child Nicotine Poisoning Prevention Act, issued an immediate stop sale order covering e-liquids containing nicotine that are bottled without special flow-restricted packaging. It's a surprise mandate issued via tweet by recently appointed Republican CPSC Commissioner Peter Feldman, who states that as much as 100% of e-liquid nicotine containers on the market are in non-compliance with the requirements of the CNPPA. The regulator immediately began sending waves of enforcement letters to e-liquid manufacturers demanding the voluntary removal of product from warehouses and vape store shelves, and if industry does not comply, CPSC threatens to declare millions of bottles of e-juice non-compliant and subject to official recall and destruction. Joining us today to discuss this disturbing enforcement action by CPSC is Boaz Green from Keller & Heckman LLP. Boaz is a regulatory lawyer with a specialty in product safety and consumer protection law. He has deep knowledge and experience with CPSC regulations and guidance, both in private practice and in government, serving as chief counsel to CPSC Commissioner Marietta Robinson prior to joining Keller & Heckman. Boaz, thanks for joining us today on RegWatch.
Thanks, Brent. Good to be here.
So let's jump into this as there's a lot to unpack in this story. Please explain for our viewers what flow-restricted packaging is.
In the 1970s, a new law was passed called the Poison Prevention Packaging Act. And CPSC passed regulations under that. And most of it is what you're familiar with, which is the child-resistant closures that you have on, say, the aspirin that you buy at the drugstore or bleach or other household cleaning products. There is a very obscure provision in those regulations that describes flow-restricted packaging. And basically that's packaging that if you you open it, turn it upside down, squeeze it or activate it once, and no more than 2 milliliters may come out. And that only applies under the PPPA, which is the acronym for the law, for substances that are specifically listed as ones that need to have flow-restricted packaging.
So for vapors who've bought the packaging now that's out there, and there's quite a few of them where they got the needle nose on it, and you have to squeeze pretty hard to get the e-juice out.
Yeah, I mean, that's basically a way to restrict flow.
What about bottles, though?
So glass bottles traditionally have not come with flow restrictors. I think that there are ways to incorporate them. So an example that I give, I have beard oil that has sort of a plastic cap that you need to shake a few times to get a few drops out. That's a form of a flow restrictor. The problem with flow restrictors for glass bottles is some of them might not be user-friendly for how vapors want to use their e-liquids, and they're also difficult to integrate into the production line. So they're an expensive option rather than moving to one of the plastic bottles that we're familiar with the needle tips.
So notice about this whole new rule, this was a surprise, wasn't it?
It was definitely a surprise. So while the law had passed over 3 years ago, CPSC never said anything about flow restrictors and never enforced it. And it wasn't until the tweet that you mentioned that came out in February that anyone had really thought of flow restrictors in relation to e-liquids.
So how much of a threat to the industry is this regulatory action?
Well, it's a significant threat to companies that have all or most of their products in glass bottles. Glass bottles traditionally have not come with any kind of flow restrictors, whereas a lot of the plastic bottles probably do comply, though they do need to be tested for that. So these are companies that are at great risk of having their products tested by CPSC, declared non-compliant, and then these companies are being asked to stop sale, destroy everything that they have in inventory and in the retail distribution chain. And they're also being told that they need to come out with public notices to their customers and to their retailers, both on their own websites, social media, and CPSC's website, describing the dangers of packaged e-liquids without flow restrictors.
So it's a business shaming almost in a way here is what they're actually asking for, right?
Well, it's a combination of, I guess you could call it shaming, or you could, it would definitely increase a company's potential liability, come out publicly saying that the products that they sold are unsafe. But it also, in terms of the ongoing business, is a huge hit. They need to destroy hundreds of thousands of dollars worth of existing inventory. Many of them would have to be out of the market for months until they can transition fully to new packaging, redesigned, new labels with flow restrictors. And during that absence from the market, I think many could lose some of their more loyal customers.
So describe for us again, you mentioned it a little bit, but I'd like to dig down a bit deeper in terms of how this particular regulatory action could be a company killer.
Well, say you're a company that has all of its inventory in glass bottles, and we definitely have clients who are in that position. If you get a letter demanding that you destroy everything that you have in inventory, recall everything back from your distribution chain, and then not get back on the market until you've been able to integrate plastic bottles, that's a huge hit. You are losing millions of dollars possibly in existing inventory, plus the costs of pulling that all back. And we're also talking about a liquid that would be considered a toxic waste once you're planning to destroy it. And that can be a very tricky issue for a company to comply with all the regulatory requirements for dealing with what would be considered toxic waste. So that's an added cost here. And then you just have the time lag between when you've stopped production and sale and when you can get all of these enough plastic bottles to fill your orders, retool your production line, design and print new labels. All of that is a huge cost. We know from our clients that even without having the time pressure, the transition itself could cost $250,000 or more. Add to that being out of the market, I think many companies just couldn't take the hit.
This sounds like a very specific application of an obscure regulation, meaning, just products with nicotine. What's the level of hazard the CPSC is trying to protect the public from here?
Well, I don't think that there's really a question that liquid nicotine could be very dangerous for children. Any nicotine is very dangerous for children. Even a single cigarette butt, if a child ate, could send the child to the hospital. So we've been aware of the dangers of nicotine in various forms for a while. Liquid nicotine might be an easier way for a child to access a dangerous amount. But if we're looking at the actual incidents, they're really not that prevalent. We have a lot of substances and products that are under CPSC regulation in terms of the safety of the packaging and child-resistant packaging that are associated with many more incidents and even deaths. And we're not seeing that level of incidence with liquid nicotine.
Well, I definitely wanted to ask, what about bleach and other household chemicals like that? They surely must be flow restricted.
They are not flow restricted. The only product that has ever been required to be in flow restricted packaging since 1973, when the regulations were passed, is furniture polish. So bleach, which is associated, it's one of the top four chemicals that are involved in pediatric poisonings according to CPSC's own reports, only needs to have child-resistant closures. Laundry detergent packets, which are associated, if you look at poison control centers, there have been twice as many exposures this year to laundry packets than there have been to liquid nicotine. Those only need to be in child-resistant closures. And even that was a very long process that CPSC worked very closely and collaboratively with industry to bring them into sort of compliance with an industry-developed voluntary standard. Even over-the-counter medicine, prescription medicines, those are all products that only need to be in child-resistant packaging. There's no flow restrictor requirement for any of those.
So it's disproportionate regulatory action.
Definitely.
So I know that much is made in the media about children and nicotine poisoning, so obviously the media scare around vaping must be driving this action, is it not?
So there's a few things that are in play here. I think there's the media. There are also a lot of the consumer advocates who have been pushing the commission for stronger enforcement. There's also been pressure from legislators who are in a couple of recent hearings, both in the Senate and Congress. CPSC commissioners were asked why the agency isn't doing more on liquid nicotine. And you've seen congressmen pull out a bottle of liquid nicotine and sort of say, this could kill a child, and I can open it and pour everything out, and a child could die. So that's the kind of pressure CPSC is getting, and it's getting it at a time when it is under a lot of pressure for perceived coziness with industry with other products. So the agency, I think, is trying to show that it's being more proactive. And this is frankly an easy way for them to show that they're trying to protect children.
Yeah, clamping down on the vaping industry, no matter what side of the political spectrum you're on, is an easy target to gain some quick virtue signaling.
It's definitely a pretty safe way to do that with very low political cost.
So what were the official steps that they took to work with the industry in order to let you know that this was happening? And so, of course, give you guys time to, implement whatever changes they wanted.
Well, they didn't do what they usually do in terms of advance notice and working with industry. Basically, what happened, there was the tweet that you mentioned on February 20th. And that same day, there was a letter from CPSC's director of the Office of Compliance to industry that was up on CPSC's website stating that it would soon send out guidance regarding compliance with the restricted flow requirement, which the letter said CPSC had never provided guidance on before. And then in early March, on March 8th, they came out with another letter that laid out a test method that CPSC said it would use when it tested product on the market.
We're showing this right now for our audience on the screen. That's this kind of contraption they put together, right?
Right. So they put together a contraption from scrap pieces that they had in their labs, partly to show that theoretically anyone with tools in their garage could put something like this together to test these packages. And then the letter said basically CPSC would now be, when it went out to enforce the CNPPA, it would be testing not only for child-resistant closures, but also for flow restrictors beginning now. There was no period of time for industry to come into compliance. The position was this has always been a requirement. We've just not given guidance on it before, and we're going to be enforcing it tomorrow.
Take us through some detail about what the tone and tenor, the specifics of these enforcement letters are.
Okay, so what happens is CPSC has field officers who are located throughout the United States. They've been going into vape shops. They've been buying e-liquids in glass bottles, taking them back to the lab and subjecting them to the tests that CPSC staff created. Once they do that, they send a very stern letter to the company, telling the company that they've tested the product, it does not comply. They consider it a misbranded hazardous substance, the sale of which is illegal. They note that selling a misbranded hazardous substance could subject you to a civil penalty of up to $110,000 per violation and up to $16+ million for a series of related violations, and even criminal penalties. And then they demand that the companies immediately stop sale, tell everyone in their distribution chain to stop sale, pull everything back, destroy it, and then issue these public notices both on the CPSC website and on their own websites and all their social media channels, telling their consumers about the dangers of e-liquids.
This is happening right now to numerous companies.
Yeah, there have been at least 3 waves of these letters that have gone out to a whole host of companies in the U.S.
Now, this must be terribly distressing for the business owners.
Well, definitely. It's a threatening letter. You have the prospect of civil monetary penalties or even jail time. And I think what makes it even more complicated is that if you're going to change your packaging to adopt flow restrictors to comply with what CPSC is demanding, then you run the risk of FDA coming around and saying this is a new product and now you need to get PMTA approval for this product because it's now in a new package.
That's what's called the FDA catch-22 on this issue, right?
Exactly. You're being squeezed from both sides, and you could be, you'll be pushed out of the market if you don't change your packaging, but if you do, you're also putting yourself in peril.
So there was no coordination then between the two regulatory agencies?
Well, there wasn't any coordination in terms of making sure that FDA was on board with what CPSC is demanding and that FDA would allow companies to change their packaging to make it ostensibly safer for children. We're also being told that there wasn't any kind of conspiracy here where they actually were in cahoots and trying to find a way to drive industry out. I think that they just, people at CPSC didn't necessarily comprehend how the deeming rule works and were really focused on their lane, which was the packaging.
So is this aggressive action in character then for CPSC?
It's pretty much out of character. I think that you can see the laundry detergent packets is a good example of CPSC with a product that was involved in a really alarming number of incidents, working with industry in a very collaborative way, working through voluntary standards, which is really the preferred approach at the agency, and really giving industry time to develop a standard and review over time whether it is effective, and also give them the time and the guidance to adopt packaging that would comply with this voluntary standard. And that's in sharp contrast with what's happening here, which is an immediate edict that this is required, and then followed that immediate, very aggressive enforcement. And I know that companies that have been dealing with CPSC after getting these letters have not been able to get any kind of flexibility from the compliance officers in terms of the timing of trying to change the packaging and come into compliance. They've been very inflexible.
So they've got their heels dug in on this.
Yeah.
Describe for us the affidavits that have been going out to vape shops.
So what's happening is that the CPSC field officers, once they go into the shops and buy these e-liquids, are then having the shop owners or managers sign an affidavit promising that they won't sell those products anymore. They don't have authority to require this, but I think that that's not necessarily something the shop owners know. So we've seen quite a few examples of these affidavits. And one thing that CPSC knows from experience can be very effective is putting pressure on the retail industry to start stocking products that CPSC believes is safer is a way to then put pressure on manufacturers to change the products that they're offering. And we know from our own clients that they're worried that their retailers won't want to buy the e-liquids in glass bottles anymore.
Now, let me ask you a question here, Boaz. In kind of the professional advice, is that should industry take CPSC threats seriously? I mean, are they just threats, or what are the real enforcement actions that they can take to actually bring these companies into compliance? Is there something that they can really do?
Yeah, so the letter itself isn't self-enforcing. So these are demands from the agency. A company could refuse to do what the agency is asking here in the letters, and then the agency would have to go to court to try to enforce it. There are a few different tools that the agency has. The agency has the power to go on its own into federal court and ask for an injunction to stop the sale of a non-compliant product, or what it considers a non-compliant product. It can also issue start a administrative litigation to force a company to recall a product and come out with public notices about the potential dangers of the product. And that is full-blown litigation, but it's before an administrative law judge rather than before a federal court judge. And the agency has the power to do that on its own. If the agency wants to get civil or criminal penalties, that's something that they need to go through DOJ. DOJ is actually the agency that would have to take that case. There's also another provision, an imminent product hazard provision under the statute, where the agency could go into court and ask to declare a product an imminent hazard. And then it would be able to both stop the sale and seek a recall of the product. That that too is always product specific, so it doesn't go against all products in the class. It would be against a specific manufacturer.
So there's a bunch of different ways that they can go. Now, but there obviously must be also some disadvantages for them to take any of those different kinds of actions. And I'd like to get your thoughts on that, because it's not like we want to try to ease people's minds in the industry, but we do want them to understand a little bit about what CPSC would have to go through to be successful in any one of those tracks.
Right. So in the tracks of getting an injunction because a product is non-compliant or getting civil and monetary penalties, they would have to prove that their reading of the statute is correct, that the statute does require flow restrictors. And we think that that would be a really difficult thing for the agency to show. The plain language of the statute, the legislative history, all point to the fact that Congress really only wanted to include child-resistant closures. And that's really been the agency's own understanding for many years. So we think that that would be a serious litigation risk for the agency, and that there'd probably be reluctance on their part to go in and do that. And the same would be for seeking a judgment that this is an imminent product hazard. I think that that would be tough to show, especially looking at the numbers that we discussed a little bit earlier today. And forcing a recall would also be difficult, because there they don't only need to show that the product doesn't comply with the statute. They would also have to prove that it is what's called a substantial product hazard, which is a difficult burden for the agency to show. Requires a lot of analysis, and would be very expensive for the agency to try to bring that kind of litigation. But if there are enough commissioners who are really aggressive about it, I think that they could push staff to try to bring some of these cases and see where it goes.
From the industry's point of view, from what you all are doing at Keller and Heckman, right? Exactly how are you standing up to these guys? And is there a venue, a court, some board that you can appeal to that can help you kind of deal with CPSC? Because if they're not talking to you, if they're being intransigent about it, like, what relief is there for the industry to at least appeal to some other legal body, or do you just have to wait for them to file a lawsuit?
We helped create an industry, the e-vapor coalition, which submitted a long letter to the acting chair and all the commissioners, the general counsel, and the head of compliance. And we also copied folks at FDA, laying out our reading of what the statute covers and requires, explaining why the incidents don't really warrant this type of reaction, and also pointing out some of the flaws in the test method that CPSC staff created pretty quickly when they created the guidance back in March. And then we also explained to the agency the whole interaction between what they're doing and the FDA's regulatory regime and the deeming rule, because our sense was that the agency really wasn't fully comprehending what a packaging change could mean for a company with respect to FDA's jurisdiction. We know all the commissioners have read these letters. We know they thought it was well done and interesting, and they're thinking it through. But we don't really know what the next step from them is going to be. We've also represented a number of companies who've received these notices, and they've incorporated the arguments that are in the industry letter to explain their different reading of what's required under the law. I think that there really is no other venue. I suppose a company could go to federal court and ask for a declaratory judgment that CPSC is wrong, but that would be very expensive. So a company is more likely to wait and see if CPSC will sue them, and then try to win those arguments if it does.
Boaz, isn't this though just about really just getting the time? Like, in the end, with the bottom line on this is that flow restrictors are probably a reality for the industry, just given the nature of nicotine and e-liquid and just the enormous amount of bad publicity. Isn't it the idea here is to just get relief from that? Or is that not even reasonable to be trying to get?
No, that's definitely basically the ask. Our ask from the agency in the industry letter was give us the time to do it in an orderly fashion, work with FDA to get clarity over whether or not FDA will enforce pre-market approval requirements for companies that are changing packaging for the sole reason of adopting flow restrictors, and explaining that this is something that takes time. You need to get the bottles, you need to retool your production, you need to change everything in your supply chain. It's not an easy thing to do right away. We pointed out that the agency routinely gives companies months, even over a year, to come into compliance with new mandatory rules, and that the agency should follow this model in how it's dealing with the e-liquid industry as well. I do think that it's a good idea for companies to adopt flow restrictors. I think it does make the products safer. It might be a little more frustrating for users, I admit, but it is safer. And I think that for the industry, given all of the political pressure that it's under right now, showing that it is taking affirmative steps to help prevent child poisoning would be a good thing.